Welcome, welcome everybody. On behalf of Dr. Ralph Knack, Paris Deputy Reporter General of IPPI, we want to give you a warm welcome to this webinar jointly organized by the Pharma Committee and the IP, Genetic Resources, Traditional Knowledge, and Cultural Expression Committee. That is going to be very special because as part of the series of webinars we have been organizing during the last 3 years, this is specifically special because we will see something quite important about this historic outcome of the Diplomatic Conference on Genetic Resources and Associated Traditional Knowledge. We will discuss about this treaty, and as Dr. Ralph Knack mentioned, is a landmark achievement after 25 years of intense negotiations and marks a significant step towards greater inclusion and recognition of indigenous people and local communities in the IP framework. For that, it will be an important discussion. We have 4 distinguished speakers, 3 speakers and 1 moderator, and we will listen to them and experience the impact about the adoption of this treaty. But before I can introduce our friend moderator, there's some housekeeping that we have to be aware. That you can see in the slides or in the screen. The questions to speakers can be submitted via the Q&A box. Please, the question session will be at the end. Of course, technical problems, please send a message to the chat box of the IPPI events. And at the end, there is a brief survey after the webinar. We will be very grateful if you let us know your feedback about. But now we have a great team and guided and by the leadership of Professor Takeshi Komatani. He, among other many activities, he's a patent attorney at Takashi International Patent Office. He's visiting professor at Kobe and Toshiba University. He has a long education profile in some schools of medicine, pharmaceutical science, law school, among others. And also at the IPPI side, he's head of the Genetic Resources subgroup of the TK and GR and ETCT committee, as well as observer of the Pharma Committee. So I'm very grateful to him because he take care of all the organization of this webinar and keep together these three great speakers, and you will really see the importance and dimension of the topic. Takeshi, the floor is yours. Thank you and welcome again, everybody.
Thank you, Martin, and thank you very much for your kind introduction. I would like to introduce the very distinguished speakers today. From the right hand, so very distinguished guest from WIPO, Director of the Genetic Resources Section, Mr. Wen Lan. He will be the first speaker, giving us a general introduction and the outcome of the most updated information from the Diplomatic Conference. And the second speaker will be John Todaro. He's the chair of the AIPPI Pharma Committee. He has been dedicated along to AIPPI activity for the last many years. He's also an IP counsel at a private pharma company. And last and not least, Dr. Mutsuaki Suzuki. He's the chair of the National Institute of Genetics, dealing with IP and other matters, including Nagoya Protocol. He has been active in this field for more than 10 years. He will give us some speech on the academic side of this impact of this treaty. So we'd like to move to the first speaker, Mr. Wen Lan. Are you ready? Okay. Good.
Takeshi,
So-
thank you so much. And Martin, thank you for the invitation. My thanks to AIPPI, the Pharma Committee, and the GRTKF Committee. It's a real pleasure for me to be with you today. The treaty was adopted by consensus in the early hours of the morning of May the 24th. So that's about 10 days ago now. And the treaty introduces a number of firsts into international intellectual property law, in particular patent law. And let me just mention two of those quickly. This is the first treaty to address the relationship between innovation and patents on the one hand, and the conservation of biodiversity on the other hand. The treaty does so by establishing a new mandatory disclosure requirement in patent law when a claimed invention is based on genetic resources and or associated traditional knowledge. The treaty shows that support for innovation and for the patent system and for the conservation of biodiversity can be mutually complementary and mutually supportive. Secondly, for the first time in an international intellectual property treaty and the first time in a WIPO treaty, indigenous peoples are explicitly mentioned in the treaty, both as the providers of associated traditional knowledge and as stakeholders to be consulted on information systems like databases that may be established under the treaty. And they also mentioned for the role that they will play in the implementation of the treaty and in meetings of the assembly of the contracting parties that will begin to meet once the treaty comes into force. I could speak at length about the treaty, about the diplomatic conference that was held towards the end of May, about 2 weeks ago, what made it a success, all the work that went into preparing for it, the content of the treaty, some of the history that led up to the diplomatic conference and to the treaty itself. What were some of the key outstanding policy issues at the beginning of the conference that had to be resolved before the end? What was the process like? What methodological modalities were used in order to help the member states to reach agreement? What happens next? And what's the link with the rest of the IGC work on genetic resources, traditional knowledge, and cultural expressions? But in the time available to me, I will only focus on a couple of these things, beginning with the content of the treaty. So the treaty says that its objectives are to enhance the efficacy, transparency, and quality of the patent system with respect to genetic resources and associated traditional knowledge. That's the first objective. And the second objective is to prevent patents from being granted erroneously. And these two objectives are achieved or implemented in two different ways in the treaty. The first is the mandatory disclosure requirement, which I mentioned already. And the second is a non-mandatory reference to databases and information systems. And I'll come back to that again shortly. The disclosure requirement. The disclosure requirement is set out, the heart of it is in Articles 3.1 and 3.2, where a claimed invention in a patent application is based on genetic resources. The patent applicants must disclose the country of origin of the genetic resources, and there's an important agreed statement in the footnote in that article, or their source, and equally, where claimed invention in a patent application is based on traditional knowledge associated with genetic resources, the patent applicants must disclose the indigenous peoples or local community as applicable, and there's an agreed statement in relation to that wording too that's important, who provided the knowledge concerned or its source. Now, in the treaty, there's a number of core terms and core concepts that are very important in Articles 3.1 and 3.2. These are defined in Article 2. The most critical terms are terms such as country of origin, based on, source of, GR, source of the TK. These are all some of the important concepts that are referred to in Article 3 and defined in Article 2. If neither the origin nor the source is known to the applicant can make a declaration under Article 3.3, and Article 3.3 provides some additional information on the state of the mind of the declarant, of the applicant making the declaration. What's the role of the Patent Office? Well, under Article 3.4, the Patent Office must provide guidance to patent applicants. It must also provide the opportunity to patent applicants to rectify and correct disclosures made. This is referred to both in Article 3, 3.4, as well as Article 5, 5.2, and 5.2 bis. There's no obligation on the Patent Office to verify the authenticity of the information that has been disclosed. That's very important, an important part of the balance, and that's in Article 3.5. And the Patent Office should also make the information available in accordance with patent procedures. That's Article 3.6. In terms of post-grant sanctions and remedies, these are addressed in Articles 5.3 and 5.4. The articles make it clear that patents may not be revoked, invalidated, or rendered unenforceable solely for a failure to disclose the information specified in Article 3. And the Article 5.4 also makes it clear that post-grant sanctions and remedies are possible in case of fraudulent intent. Finally, on the disclosure requirement, I'll mention Article 8 that provides for a review of the content and the scope of the treaty 4 years after it comes into force. On information systems, these are addressed in Article 6. As I've mentioned already, parties may, they're not obliged to, they may establish information systems such as databases in consultation with indigenous peoples and local communities and other stakeholders. And the Assembly of Contracting Parties may establish one or more technical working groups on this particular issue, such as to address accessibility of the databases to officers with appropriate safeguards. I'll turn now to some of the history, and just to recall that this particular idea was first introduced in WIPO quite a long time ago, 25 years ago to be precise. So the treaty has had a gestation period of exactly 25 years. It was Colombia that first proposed the idea in 1999 when a new patent law treaty was being discussed at WIPO. A diplomatic conference had been set to adopt that new treaty, which is a formalities treaty, in May 2000. But in September 1999, Colombia, with the support of some other Andean countries, proposed the inclusion in the patent law treaty of a disclosure requirement, not exactly the same as, but broadly similar to the one we have in the new treaty. The proposal was at that time not agreed to, but agreement was reached among WIPO member countries that the PLT, the Patent Law Treaty Diplomatic Conference, would continue, and that treaty was then adopted in May 2000, but that a separate body would be established to address the Colombian proposal, and that body was established also in 2000. It began to meet from 2001, and that is, of course, the IGC, the Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge, and Folklore. Meanwhile, outside of WIPO, member countries of the Convention on Biological Diversity were meeting. The same idea had come up in meetings held under the CBD in the mid and to late 1990s. In 2002, the CBD member states invited the WIPO member states to conduct a study on this matter, which we did, and we published that in 2002. Other things were happening outside of WIPO. The Nagoya Protocol was adopted in 2010. A couple of years earlier, in 2007, the UN Declaration on the Rights of Indigenous Peoples was also adopted. So there were things happening inside of WIPO and things outside of WIPO. In the IGC, the first time that there was a consolidated text on genetic resources and associated TK was in 2012. So that's now 12 years ago. It was a very long text, but it did reduce what was about 5,000 pages of documentation into a relatively manageable document of about 20 or 25 pages long, with many brackets, many alternative options. In 2019, the then chair of the IGC, Ian Goss from Australia, prepared his own text, which was a kind of a distillation of all of the work that had been done by the IGC for the past 18 years, effectively, and that became known as the chair's text. And then, actually quite unexpectedly, in July 2022, the WIPO General Assembly, all the member states of WIPO, agreed by consensus to convene a diplomatic conference on genetic resources and associated TK by no later than the end of 2024. And that, of course, was the diplomatic conference that we have just held. So I hope that gives a little bit of the history, both inside of WIPO and outside. I will end with what's next. So my team and I are obviously now pivoting to, upon request, helping countries who wish to ratify or accede to the treaty, to understand the treaty fully in relation to their national or regional laws. I might mention that there's about 33 or so countries that already have a disclosure requirement like this in their national laws or in their regional systems, like the Andean countries. And so upon request, we will be helping countries who are considering whether to ratify or accede to the treaty. The treaty does provide, by the way, that it will come into force 3 months after 15 countries have either ratified it or acceded to it. Indigenous peoples and local communities, as I've mentioned, are also referenced in the treaty, and they have a role to play, and we'll be providing support to them. And again, upon request, once a country has ratified the treaty, it will have implemented the treaty in national law, and we'll be assisting countries if they ask us for assistance in how to do so. The negotiations of the IGC resume at the end of this year, also on genetic resources, but perhaps mainly on traditional knowledge more generally and cultural expressions. I'm happy to answer some questions on that if there are any. And then the other thing we, of course, are looking at now is Article 7, that talks about mutual supportiveness with other international agreements, and in particular, the Patent Cooperation Treaty, which is a WIPO treaty. There's a footnote about that to Article 7, and we're already beginning to work with my colleagues in the Patent Law Division, or the PCT area, to see what are the changes that member states may agree to, the member states of the PCT may agree to implement the treaty within the PCT system. So Takeshi, with those words, I thank you for your time, and I pass the floor back to you. Thank you so much.
Thank you very much, Wen Lan, for a nice speech and a very complete, I would say, speech, and we can learn everything from your speech. So next, we'd like to transfer the floor to John Todaro, who is the chair of the AIPPI Farmer Committee, who will be probably doing some presentation from the industry side. John.
Yeah. Thank you, Takeshi. Thank you for the introduction. Thank you very much for inviting me to speak. And I wanted to start off by actually congratulating Wen on the accomplishment of the treaty and his team, and acknowledging the tremendous amount of work that the group undertook to make this happen. And thank him for his presentation. Next, I also wanted to thank and acknowledge the work of the Genetic Resources and Traditional Knowledge Committee of AIPPI, really an excellent committee with Martin and Takeshi. I've been happy to work with them on projects over years, and just thank them for keeping the AIPPI community aware of this issue and hosting some interesting presentations over the years on this issue. And also wanted to put in a little point of acknowledgement of my own committee, the Pharma Committee. So we're probably one of the bigger committees in AIPPI. We have over 50 members from over 30 countries. We study issues that are of IP law and practice that impact on the pharmaceutical industry and the community. And we're always looking for new members and observers. We work closely with not only the Genetic Resources and Traditional Knowledge Committee, also the Biotech Committee and the TRIPS Committee. So with that, I'd like to get into the treaty. And as Takeshi said, my role here is really to talk about some of the issues that have been presented. As Wendy pointed out, there's 25-year history of this treaty. So over that 25 years, there's been a lot of issues presented from stakeholders, including from the industry side or the innovative side, inventors, and with industry with respect to genetic materials. That does largely include the biopharmaceutical industry, but there are other industries that have that are invested in this information, including agricultural, food sciences, others working with perhaps studying enzymes or studying the genetic materials and the way that genetic materials react and the sort of biological cascade that occurs in nature, in plants and people as well, and how that impacts in health and other areas of innovation. So these issues are important to a lot of stakeholders in industry and in the innovative community. And why is it important? Because they recognize the value of intellectual property, how the standards that we've established in TRIPS and the international system of intellectual property has enabled a lot of investment in research to allow for the advancement of science in health and other uses for this for genetic materials, and studying the reactions of genetic materials. So there's a real concern that a treaty that imposes new obligations on innovators with respect to genetic materials may harm the innovation system. That's the background why this was an issue that was important to the industry and to the innovative community. And with that, I point to what Wend also talked about, the objectives of the treaty in Article 1, to enhance the efficacy, transparency, and quality of the patent system with regard to genetic resources and traditional knowledge. And 2, to prevent patents from being granted erroneously for inventions that are not novel or inventive with regard to the genetic resources and traditional knowledge. And I think it's important that countries, when implementing this treaty, and the Congress, as it continues to study the treaty, keep those objectives in mind and make sure that anything, the way this treaty is implemented complies with those objectives. We can turn to the next slide, please. So now I'm going to talk about some of the concerns raised by industry during negotiations, and after that, how those concerns have been addressed or maybe not addressed, or what the future holds. And of course, a lot of this is uncertain because we really have to see how countries implement the treaty. One of the key issues is issues where the country of origin of genetic resources is disputed or unknown. There have been instances in the past where more than one country has claimed to be the country of origin of genetic resources. There was the broad definition of genetic resources as well, which makes that possible that there would be more than one country of origin. And that, of course, is a big concern to industry or to anybody filing a patent application, frankly, around the world. If there's going to be a requirement to identify the country of origin, what if more than one country claims that country of origin? Are you going to have, be put in an impossible position of having, you're not going to make everybody you're gonna run into problems with at least one country in that kind of situation. Another issue is the scope of genetic resources. There is a broad definition in the treaty, but there are two areas that are of main concern to the innovative community. One is human genetic resources, which of course are studied during clinical trials and drug research. Of course, there are tremendous ethical and privacy requirements around the world in the use of human genetic resources. But will the inclusion of the human genetic resources in a treaty complicate clinical research and digital sequence information? So much of the genetic resources over time then becomes sort of digital sequence information, which may be stored separately, no longer connected with its origin. So if that's included, that will create a tremendous burden potentially to researchers. And the trigger requirement, that is, how to determine when the country of origin must be identified. What is the standard for inclusion? And Wen talked about this based on is the language used in the treaty, and we'll address that. But these are the issues that were of great concern during negotiations. Another one, that the treaty does not contradict the TRIPS requirements for patentability, right? So TRIPS obligates signatory countries to grant patent rights if an invention is novel, has an inventive step, and has industrial applicability. So is the new disclosure requirement putting in another obligation that would contradict TRIPS and that not allowing for the grant of patent rights when those standards are met? Another issue was, will the treaty apply retroactively, which also worried industry and innovators. Next slide, please. So the country of origin disputes language is in Article 3. Wen talked a little bit about it, and I think it's has addressed some of the issues of concern. So the definition of country of origin means the country which possesses those genetic resources in situ conditions. And in situ conditions is further defined. I don't think we need to go into that, but the definite point is clearly more than one country could claim to be the origin. So 3.1b, 3.2b, for both genetic materials and for traditional knowledge, if the country of origin is unknown, or if the applicant doesn't know or can identify the community or indigenous people provided the traditional knowledge, the applicant can disclose the source, or must disclose the source of the genetic resources. That's certainly a way of complying, which the country of origin may not be known, so that gives an option under certain circumstances that could be helpful. And also there is a requirement that under 3.3, or so I should say an option, if none of the information is known, the applicant can make a declaration to that effect. Again, that could be helpful. Some concerns. One is traditional knowledge is broadly defined to include information obtained from scientific literature or patent applications. So that would be sort of at a point where it was already could have been separated from the real source, the indigenous community, for example. So there's certain it would be difficult sometimes to identify traditional knowledge clearly as under such a broad a definition. And the other point is 3.4 of the treaty gives the offices the right to provide guidance, or that says they shall provide guidance to patent applicants on how to meet the disclosure requirement. So, there's a little concern there from some about how countries will provide guidance, and will that be an issue for compliance? Of course, we also note that many countries already have rules and laws and practices about disclosure requirement before the treaty. So there is a set of laws already in place that may impact, that may not be disturbed by this treaty, but may impact the way the treaty is implemented in various countries. Next slide, please. The scope of genetic resources. So one provision which was helpful in my opinion, I think in the opinion of most researchers. Footnote 1, the definition of genetic resources is in line with the manner in which the term is understood in the context of the Convention on Biological Diversity, not intended to include human genetic resources. So I think that addresses a concern from industry, from the pharmaceutical industry in particular, about how this might impact on the use of, the kinds of genetic material that needs to be studied to create a drug in a clinical trial. So that's probably a favorable result from the innovator side. But the issue of digital sequence information is not so clear. And as I pointed out before, right, typically databases that maintain drug sequence information, which we call digital sequence information, DSI, do not reference the genetic material of the origin, and it may be derived later from the discovery of the genetic resources. So it may be, over time, later on, the DSI is isolated or identified and maintained separately. If the definition includes DSI, that could be a big burden on researchers. And we have to acknowledge that this is an issue in the Pandemic Preparedness Treaty in the context of access and benefits sharing discussions that are ongoing. I think many commentators have pointed out the real need to ensure that DSI, particularly with respect to pathogens, is shared freely and quickly in order to enable researchers to quickly begin research. We're, of course, referring to communicable diseases such as potentially another pandemic, or, of course, the coronavirus. Very early in the coronavirus, as I think most of us know, the DSI about the virus was shared freely. That enabled researchers to get an early start, and I think that helped save lives and helped advance science. So that's an important issue to the innovative community. One that I don't think is, the DSI issue is, I don't think, completely resolved in the treaty. Next slide. The trigger requirement, that is, when do you have to disclose genetic resources? And as Wen said, the term is based on genetic resources. The invention is based on genetic resources. The definition of based on, which is in the treaty, requires that the genetic resources, two elements there, must have been necessary for the claimed invention, and that the claimed invention must depend on the specific properties of the genetic resources. Some commentators have read this as somewhat limited. Genetic material is used in research for many reasons, for screening material, for starting research. Here, I think the requirement is that the invention must clearly be, this material must be necessary for it, and it must depend on the specific properties of genetic resources. I think that's somewhat limited. I think that is actually a good result for the innovative community. It solves the purpose of the treaty, that is the proposed, the goals of the treaty, by disclosing genetic resources and by preventing improper patenting, while at the same time not burdening researchers with having to over disclose, if you will, genetic materials that are not so closely connected to the invention. Next slide, please. And then TRIPS, right? So, like I said, TRIPS obligates countries to grant patents when the standards of novelty, inventive step, and industrial applicability have been met. What's going to happen if we have a new disclosure requirement? Does that mean you can't get a patent even though you met those standards in TRIPS? That's a big concern to the innovative community and to the industry that has invested in research and in order to establish intellectual property rights. So one encouraging point, as Wen pointed out, Article 5.3 states that there will be no revocation or invalidation or unenforceability solely on the basis of applicants' failure to disclose. So there needs to be more than that. And then Article 5.1 does also require the office to provide an applicant the right to disclose, to provide the required disclosure information to address a failure to do it and to rectify the failure to disclose. Those are all favorable results from the point of view of the innovative community. 5.4, however, states that each party may provide for post-grant sanctions or remedies where there has been fraudulent intent in regard to the disclosure requirement. So that is a concern for the innovative community. Fraudulent intent is not defined in the treaty. Not sure how much the issue of fraudulent intent is addressed in the patent offices around the world. In the US, we do have the duty of disclosure, of course. We do have issues with respect to fraudulent intent or intentional failure to disclose, and those issues. So there are some grounds for understanding that in the US, but I'm not sure that that's the case around the world. So that's a concern. And I also point to footnote 5, nothing in this treaty shall derogate from or modify any other international agreement. So that's an encouraging a footnote for the agreement. But I think the interaction with TRIPS remains an issue for industry and for the innovative community, and we'll see how countries interpret this treaty going forward. Next slide, please. And then retroactivity was an issue because there is concern that much of the material that researchers work with has collected many years ago, and are applicants going to be forced to go back in time to comply with the treaty to provide disclosure requirements, to provide information, country of origin information, etc. But Article 4 provides the treaty shall not apply to applications filed prior to the entry into force of this treaty with regard to that contracting party. So from the standpoint of industry, from the innovative community, that was a good result. Next slide, please. So as Wen said, the treaty enters into force 3 months after 15 parties have deposited the instruments of accession. There are a number of questions that remain, and I guess we will watch how countries interpret the treaty. One question is, will the PCT be amended to require a disclosure requirement? There's a suggestion, of course, in the treaty that it may be done. As I pointed out, fraudulent intent still remains an issue that's of concern. And the procedures required by 5.1 for complying, as I said, there are a number of countries that do have disclosure requirements around the world, and they do have procedures in place. So those procedures, will they be impacted by the treaty? That's something that we need to keep an eye on. Next slide, please. Countries have various rules on disclosure. Not all of them say that disclosure requirement is mandatory. So in some countries, it will be made mandatory. And some countries have disclosure requirements for genetic resources, but not for traditional knowledge. So that's likely to be a change for countries that sign on to the treaty. And, Article 5 then limited in revocation, invalidation, or unenforceability, saying that it can't be solely on the basis of applicant's failure to disclose. In some countries, that could be an issue because the current law does permit for the invalidation of patents if there's failure to disclose without regard to intent. And next slide, please. And we're also watching the Article 8 provision that 4 years after entry into force, the contracting parties will conduct a review. And I think there's interest in seeing what issues come up. However, under Article 14, revision of the treaty requires a diplomatic conference. So once again, congratulations to Wen and his team for the work on the treaty and the final signing of it. Takeshi, I'll pass it back to you.
Thank you, John. And there's many slides and information, post and pre and post. And you also gave several questions, but we do have a question answer section, so we can address this issue later. So to the floor, we have a Q&A session, so please feel free to raise any questions to the Q&A box. So the last, but not the least, Dr. Suzuki from National Institute of Genetics, who summarizes some opinion from the academia, from the respect to the impact from this diplomatic conference. Dr. Suzuki, please.
Okay, thank you, Takashi. And yeah, I'm very happy to have about this great chance. And also, I'm very thankful to the Mati and the PPI. Also, I would like to I would like to show the academia's opinion based on the interview and also seminar. First of all, I have to introduce. My name is Mutsaki Suzuki. I'm the director of the Energy Innovation. It's a office of the Industry University Collaboration and IP. And also, I'm founder of the ABS support team. Our ABS support team is doing the assist of the ABS implementation in university. And also, I'm also Japanese governmental delegate from COP10 to COP15, maybe COP16. Yeah. And also, I'll show the various necessary actions related to genetic resources. In addition to the CBD, NP, NAMA protocol, and ABS, there are already a number of the items that need to be addressed by academic discipline using the genetic resources, such as the export control and MTA, ITPGR CITES, Cartagena Act, plant protection law, and many. When the academic researcher study with the genetic resources, they and the university have to work with these items. Now, diplomatic conference document, new WIPO treaty was adopted. Now, WIPO neutrality added the environment of the around ABS. Okay, I'll show the opinion of academia and how should it respond to the new treaty. I'll show you the summary of the opinion. Opinion were divided into two main groups. There are those who thought it would not have not much on an impact, and those who were concerned. The reason for those who say it won't have such an impact is the term in neutrality seems to be basically acceptable, and also some countries already have domestic measure, and special genetic resources are rarely mentioned as a patent claim, private invention level. Researcher usually indicate country of origin. And I'll show you the example for the researcher usually indicate country of origin. This is an example of the researcher usually. Okay. Sorry, something wrong. Okay, now it's okay. When genetic resources were genetically analyzed, researchers should register from genetic resources using the sequencer. Researcher got the result of the sequencing nucleotide sequence, and researcher should register the DNA sequence information to the INSDC. INSDC is the collaboration of the DDBJ, NCBI, EBI, EMBL. Because researcher need the accession number before submission of the paper. And INSDC has made it rules that the location of collection must be. INSDC, it's a notice at the 2023. INSDC decided the sequenced sample should be indicated to the country level. So that already researchers have to submit and indicate the location of the collection of the genetic resources. Example 2, researcher, when they submit to the journal, the source of the genetic resources is described in the material method section. This is an example of the sea black sponge. From this sponge in sea, from this sponge, cancer drug has discovered. This is a paper of the isolation of the helicondrome. This is a material and method section. Helichondria, Okadai, Kadota was collected on the coast of Aburatsubo in the Miura Peninsula, which is the south of Tokyo. This is Tokyo, and Aburatsubo is here. This is an example of the this example of the researcher usually indicate country of origin and collection location. Okay, now let's move to the concerns. Concerns is a relationship between the neutrality and the national law is not clear, and the detailed procedure are unclear. The handling of ATK, associated to traditional knowledge, at a university is not clear. Most researchers are unaware of the neutrality and concerned that the decision was made without the researcher's opinion. I also think the researcher opinion is very important. Okay. And these concerns, how to deal with it. First of all, discussion on how to respond to the neutrality in each country. Discussion is a very important, and also with stakeholder around this neutrality. There is a many stakeholder. Also, researcher is one of the main stakeholder, including the researcher, and also another IP specialist. In each country, discussion on how to respond to the neutrality is necessary. And also, secondly, monitoring change in patent law each country. I had, according to the adapting of the new treaty, many countries have to change to the based on new treaty in patent law. Yeah, this information, yeah, every patent related people is necessary. And also thirdly, transmission of the information and also awareness rising because the most researchers are aware of the new treaty. So that aware rising is necessary, and also opinion gathering. Yeah, to the next step, gathering opinion is indispensable, and also patent disclosure requirement and other regulation compliance should be also double checked in the university side, because patent disclosure requirement, researcher and university staff need to the check of the country of origin is accurate, and also beside of the PDR, another regulation compliance such as the Nagoya Protocol, CITES, and also export control. Yeah, they need to check its compliance, so that university side double check is necessary, and also these for doing the for proceeding these I want to request. We would like to, from the view of the academic side, WIPO should collect up-to-date information on the national law and operation of each contracting party. For example, CBD side, they made the ABS clearing house, so that WIPO also should collect the up-to-date. Up-to-date is a very, very important word, up-to-date information, and provide us, and and also WIPO should avoid discussing on the inadequate review of the treaty until it comes into force and impact of the new treaty. So that now impact of the new treaty is unclear. Nobody can see, and so that I worry about how its impact of the new treaty on researcher and also academic society around the world. And also, this time, new treaty is a tool to improve the transparency of the patent system. It is appropriate that the new treaty was not linked to ABS, because I think ABS and DSI is not linked in this treaty. Thank you. Thank you very much.
Thank you. Thank you very much, Dr. Suzuki, about some opinion from the academic side, which it sounds like more pessimistic than optimistic. So now all the three panelists first gave us a presentation, and there are some questions from the floor as well as a question from the speakers. So I have already collected some of the questions and summarize it in my slides so I can share with you. So to the floor, the audience, we also appreciate you if you have any questions, please input into the quick Q&A session. Thank you. Okay, so there are two questions and several questions. So starting from the very general questions. Sorry, too much. With respect to the new treaty in force in a couple of months, you see any changes from the WIPO patent office side, especially WIPO and academics, and then academia and industry side, and maybe starting with when?
Takeshi, sure. And just a quick word of thanks to my fellow speakers. Thank you for your wonderful presentations and very thought-provoking perspectives and also questions. The treaty is very new, I should say, straight away. Of course, it was only adopted 10 days ago, and so I'm certainly still processing many parts of it. In relation, Takeshi, to your first question, the treaty has been adopted by consensus. It's been signed so far by 31 countries. We're expecting more signatures in the next weeks and months. It's open for signature for 1 year, but it only comes into force, formally speaking, after 15 countries have ratified the convention or the treaty or acceded to it, and then 3 months have actually passed. So the treaty is not yet in force. And it won't come into force. I don't want to put a time limit to it, but typically these things take several years to come into force because in order for a country to ratify the treaty, it has to have implemented the treaty in its national systems. And now I'm beginning to get to answer your question. So I think what will happen in the shorter term is patent offices, the IPOs, will begin now to look closely at the treaty text, compare that with national law. Either they have already a patent disclosure requirement in their national laws that may or may not be similar to what's in the treaty. And I can't express views on, I can't interpret national laws, of course, but there could well be cases where the national law is not identical to what's in the treaty. And then there's countries who have nothing at all, who will have to start from scratch. So, yes, we expect patent officers, policymakers, parliamentarians at the ministerial level to begin now to look from a policy perspective and then a practical implementation perspective with a view to ratifying or not the new treaty.
Okay, so maybe it's better to go to the next question, second one. So probably, so are you going to collect the information? This is from the Dr. Suzuki's question. So WIPO will assist us in information sharing, right?
Yes, sure. So we already have a database of all the laws, the national laws that have a disclosure requirement in their laws, as I've mentioned, and Dr. Suzuki mentioned as well, and others mentioned. About 33 or 34 countries already have this in their national systems. We have that database. It's publicly available. Dr. Suzuki, I assure you, thank you for the reminder. We will definitely now go and look very closely again. We did update it just before the DIPCON. We double-checked everything, triple-checked everything. We'll continue doing so. And of course, as countries over the next months and probably years begin to implement the treaty, we will constantly update the table, certainly.
Oh, thank you very much. Yes, thank you.
So probably comes to the first question. So academia will be preparing, especially I understand Dr. Suzuki is involved with preparing INSDC system. So this kind of system will be updated, or we just see what the law will change. So Dr. Suzuki, probably you're just waiting for the national or the international law will be amended, right?
Yeah, we have not yet start discuss how to yeah.
Maybe
However,
difficult to answer.
However, we are very eager to do the capacity building is we are doing so that according to the capacity building principle, we can help of the capacity building and also we would like to help of the other countries as a other countries so that in personal opinion we'd like to help and also we would like to collaborate with the how to make of this situation. Thank you.
Thank you very much. So, John, do you have any some changes from the industry side or unchanged?
Yeah, thank you, Takeshi. I think what Wen said was really on point. We just have to wait to see how the treaty plays out when it's put in force. There's a lot of laws around the world that may be impacted here. So there's a role for stakeholders such as industry, such as the innovative community, to keep an eye on how the law, how the treaty is implemented in various countries. I think that's what me and some of my colleagues are focusing on right now.
Thank you.
And also, Takashi, and I would like to add is another information and when obtaining the genetic resources, sometimes it is essential to record where they were obtained. When application in patent application, the source should be double checked for the correctness. And with the registration should be also be double checked. Thank you.
Thank you. So you mean, so Dr. Susi, you meant from the, not only from the patent disclosure requirement point of view, but also some other requirement like
yes. Yes, total risk management of the material, genetic resource is important, I think.
Okay, thank you. So we have some questions. So this is the A question is from the floor. As far as my review of the treaty, I have not yet sorry, there's a bad presentation. Sorry, I can't see it. So this is better. I have not noted any consequences for non-compliance with the disclosure requirement. How have been this point evaluated during the negotiation of the treaty? I think Wen can probably answer.
Yes, sure. And thank you to, it was Soli Kobab, I think, who asked that question. And it's not the norm in WIPO treaties for there to be a compliance mechanism. What I would say, though, is that in Article, what's become Article 9 of the treaty, it does oblige the contracting parties. If you look at Article 9.1, contracting parties undertake to adopt the measures necessary to ensure the application of the treaty. So that is the article that ensures that contracting parties, in becoming contracting parties, will implement the treaty in their national systems. But we don't have, as you have in the WTO, We don't in WIPO treaties have the mechanism to ensure compliance.
Okay, thank you. There are one more question to Professor John. So dear speakers, many thanks for presentation. Questions to John Todaro in view of the Article 4, the retroactivity and uncertainties due to a non-implementation of the treaty at national level. Would you expect the wave of the division application to be filed just to comply with disclosure and other requirements of the treaty? Can you answer?
Thank you. Yeah, thank you, Takeshi. So it's a good question. I really haven't thought of that as an plan, but I think that's could be an option. I think the Article 4 language is pretty good. So we will just need to address this issue on new patent applications after the treaty is in effect. But the issue that I have, though, as a U.S. attorney, right, fraudulent intent in the U.S., at least with respect to the Patent Office, is quite severe. U.S. patent attorneys know that if there's a violation of the duty of disclosure in a certain patent application, you can't solve that by filing a divisional application and then solve the problem in the new application. You're stuck with the problem pretty much. So, you know, it's a hard standard to meet, but when it's met, it's difficult. So that didn't occur to me as an option in the US, but it's worth thinking about as far as filing divisional applications. So, but again, I think the standard of retroactivity is pretty good from the point of view of the innovative community. Non-retroactivity, I should say.
Yeah. The Article 4, I think I found this very good. Yeah, thank you very much for your opinion. So this one is the third question from the floor. I have seen a fourth question coming, but I just read the third one. Taking into account that many countries don't have this in the national legislation, is WIPO going to have some workshops or technical assistance so countries can implement it in the right way? So this is a question to when again.
Yeah, certainly, and it's a great question, and it's very early days. The treaty is still literally sort of warm out of the oven. We haven't yet turned our mind to this kind of thing, but in principle, of course, we will be doing a couple of things. You know, updating the website to put the treaty text up in a very accessible manner. We're going to produce a very informal summary of the treaty. And I take into account, Mutsuaki, your point about researchers. I've made a note of that, so thank you for that, because of course we think always of the Patent Office, innovators, indigenous peoples, but Mutsuaki, thank you. You've reminded me that researchers and universities are another important stakeholder group that's implicated by the treaty. So we'll be producing some materials for all these different groups to introduce the treaty, to explain the treaty. The only thing in relation to the way the question is phrased is we won't be advising on implementing the treaty in the right way, because in the right way, I think, is something best left to the member states. Who the contracting parties. The treaty is open to interpretation in some parts, and I don't think that we will have, as a secretariat, we will have you know, particularly narrow views on what is the right way. We'll provide information on the treaty, on the different options under the different articles, but I think we'll be very careful to leave it to the member states to interpret the treaty and their own laws, of course, and then implement the treaty in the way that they think is best.
Thank you very much. I think time is running up, but one more question from floor. So is it possible that a fine can be imposed by national law for non-compliance? Maybe Gwen can answer, probably.
Yes, and others, you know, I think it's in principle, Article 5 is quite broad. If you look at Article 5.1, each contracting party shall put in place appropriate, effective, and proportionate legal, administrative, and/or policy measures. subject to correction, I think some of the national laws, and I won't make a mistake in trying to mention some of the countries, but if my memory serves me well, some of the national PDR systems do have fines for non-compliance. So they sort of out of the patent processing system. And so I would imagine that drawing on national experiences, that some countries in implementing the treaty might make provision for fines.
Okay,
Yeah.
thank you very much.
I agree with Wenda. I mean, I think the Article 5 does give authority to patent offices to set up these procedures, and fines certainly could be contemplated. The issue then, it goes the limitation on invalidity, unenforceability, that doesn't impact fines.
Yeah, thank you for clarification. Maybe time is running up, so I have to stop the quick Q&A session. Thank you for speakers and panelists on the floor and raising questions and interesting questions and discussions. So the new treaty has just started, so we'll see what happens in the next couple of years, not the months. I have to correct that time frame, but so we'll see in the next few years what development will be observed. So I have to probably comes to give the floor to Martin. So thank you very much for the panelists for giving us informative discussions and presentation. Martin?
Yes, thank you, Takeshi. Thank you, Wen, John, Professor Suzuki. It was a real great presentation that now opens a new chapter for analysis, study, and is the essence of IPPI, to continue studying how to contribute to the international community with WIPO to the permanent improvement of the IP system. And it is a very good example how it works. We really appreciate that we see how its development in the national laws and what Wen says, how WIPO provides some assistance to some countries to really implement the treaty and see how they became members. Before we said goodbye, I want to just invite you to another series of webinars. As you might know, APPI with the cooperation agreement with the CP, we have a webinar on 4th of July. We have been a series of webinars related to IP and climate change. And this second webinar on 4th of July will be trends in IP protection of green technologies. Even we have some WIPO speakers already confirmed. We're very happy to have them to provide this scenario. And also we will continue with this series of webinars with this committee, the IP and GRTK and Pharma on September 4th. Please stay tuned. We are organizing. Takeshi is working very hard as usual. So we really appreciate on that. And as it says in the slide, keep an eye on IPPI LinkedIn and email communication for details. It will be very interesting works done. And also, and the next one, please, also, please take care of the early bird for the One Show Congress. Has very well response. Most of the people have really responded and take advantage of the 9th of July early bird. And I look forward to see you in One Show, all of them. And again, thank you all for your time, all the audience, the different schedules. And again, Takeshi, Wen, John, Professor Suzuki, the party just start beginning. It's a new chapter. Thank you very much, all of you. Thank you.